じゃあ、時間になりましたんで、基本的にこれ、所内セミナーということで、やらせていただきます。録画しますんで、場合によってはクライアントさんの方で見てみたいと言われる可能性もありますので、その感じなんですけど、気軽に、やっていただけたらと思います。じゃあ、Ladies and gentlemen, this is Mr. David McCrosky.
Thank you. So I am David McCrosky. I'm a former primary patent examiner at the United States Patent and Trademark Office, and now patent attorney at the United IP Counselors. This is a picture of the patent office in Alexandria, Virginia, the headquarters. Today I'm going to talk about the 6 main divisions inside the patent office. My 14 years of experience has given me insight into how to navigate these 6 main divisions and focus on efficiency, which in turn will secure higher quality patents in less time with fewer costs and fewer office action responses. The first division is the pre-examination division. The applications go here first, and based on my experience, I estimate that about 5% of applications are rejected at this stage. They are rejected for basic typographical errors, problems with the drawings, missing documents, and inconsistent information among the documents. For example, brief description of the drawings is a common error that is seen, where the brief description of the drawings will talk about just figure 3, for example, but in fact in the drawing there's a figure 3A and figure 3B. The staff at the pre-examination division will catch things like that and kick it back. Another example is relevant to Japanese applications is would be a problem with transliteration. So in other words, if the application data sheet says Sato with S-A-T-O, but the declaration has the last name as S-A-T-O-H, that would be kicked back at the pre-examination. Even though it's only 5% of the applications, any kickback costs time and money to correct. So our focus at United IP Counselors is to combat this by having a checklist with the criteria that the USPTO looks for, so we can keep applications moving through and minimize errors, which saves time and money and lowers resubmission costs. Central Docketing is the next stage for these applications. This is where the staff will determine what technology the application is directed to, assign classification numbers to the applications, and then distribute these applications to the examiners that specialize in these certain technologies. They're experimenting with AI and algorithms to assign these applications to the examiners. So right now the algorithm will assign these applications to the examiners based on their workload. So in other words, if the examiners that specialize in a certain technology have 20 applications on their docket, but one of the examiners has 19 applications on his docket, then that newest application will be assigned to that examiner. It's based on workload. So the next stage for the application is at the examination division. This is where I spent my time at the patent office. 14 years at the USPTO gave me insight into the thought processes of the examiners, understand the docketing systems, the process by which they review applications, and the metrics by which the examiners are evaluated to determine whether they are successful or not. All of these I can use to deal with the examiners and negotiate with them. The examiners also will reject nearly all of the applications, nearly 100% of all the applications. First action allowances do happen, but they are rare. Here I've listed the common reasons for rejection. Usually it's one or more of these reasons. About 50% of the applications, in my experience, have a lack of clarity, rejection. And so my focus is to review these applications and for things such as antecedent basis, confusing language that I feel like the examiners might object to, if there's missing structural elements in the claims, and then also if there's means plus function in the claims, determining whether that means plus function, in other words, invoking 112F, if that section 112F, if that means plus function is clearly claimed or not. So what I've found is that there's been, especially with Japanese applications, it's confusing as to whether this means plus function mechanism is being invoked, the 112F section is being invoked. So the claim either has to clearly invoke this means plus function, or it has to clearly not. There can't be anything in between. And I'm going to, in the next slide, I'm going to show an example of this. So here's an application that I examined. This is Japanese company NTT, Nippon Telegraph and Telephone. And so in this application, I rejected the application under 112B for the term large. At the first line there that's highlighted, the term large was in the claims. That's a relative term. Examiners are trained to spot relative terms. So what's large to me might not be large to you, or it's a subjective term. And so the examiners are trained to spot these things, and this is the kind of thing that I can review in claims and spot before the application is filed, to save on costs and avoid these 112 rejections. The second line here is the unclear section. So the language was unclear as to what was going on. For some reason the claim just mentioned other cases, didn't refer to what the cases were. It was confusing language, and so I rejected this application because that term other cases made the claim unclear. And then finally, I also rejected the claim because it was unclear whether the means plus function was being invoked, whether the section 112F was being invoked. The claim said something about a feature value extraction step, but it wasn't clear to me whether that was clearly invoking 112F or not, and so I made a lack of clarity rejection in those. The common complaint among examiners is that their interpretation of claims is very broad. The examiners are supposed to supposed to take an interpretation that is called the broadest reasonable interpretation. However, examiners often are accused of taking a unreasonable interpretation or simply a broadest interpretation. How that can be combated is pointing out to the examiner that the plain and ordinary meaning of a claim is what should be given to the claim limitation. Citing the dictionary definition to the examiner is useful, and pointing out that the examiner's unreasonable broadest interpretation is contrary to use in the specification. So in the next slide I'm going to give you an example of that. So this is an application that United IP counselors appealed last month. The examiner rejected this application, saying that this opening in the middle of this part here was a slit. The claim had the word slit in it. As you can see, that is not a slit. A slit is defined as a long, narrow cut or opening. However, this examiner pointed to this large opening in the part and said that was the claimed slit. So we tried to deal with the examiner and convince him that that was inappropriate. However, we ended up having to appeal to the Board of Patent Appeals. This next slide is an excerpt from the appeal brief that we filed last month. So we told the examiner two things. We told the examiner, one, the interpretation that the examiner is giving of the slit is contrary to the ordinary and plain meaning, and you can see that's in the light blue. and we cited the dictionary definition of a slit, a long, narrow opening. The second argument that we made to the examiner is highlighted in light purple here, and that is that the term slit is contrary to the use in the specification. And so looking at the last two lines here that are highlighted in light purple, you can see that we pointed out to the examiner the use of the word slit in paragraph 41 in the specification and our illustration of slit in the figure 5 is indeed a long, narrow cut or opening, and therefore the examiner's unreasonable broad interpretation is inappropriate because the large opening in the prior art is contrary to our use of the word slit. And so I had the pleasure of working for a judge at the Patent Trial and Appeal Boards for 4 months, and I'll get to that later, but based on my experience, these are the kinds of things that the judges look for. The judges are also irritated, I guess could be the word, with the examiners for taking unreasonably broad interpretations. And so these two things are commonly cited by the examiner, commonly cited by the judge: dictionary definition, ordinary plain meaning, and contrary use in the specification to reverse the examiner. So we're hopeful that the judge will reverse this examiner's rejection and we can get this application allowed. A question that I'm often asked is how can applications get to allowance faster? Well, there are some ways, but they may not be beneficial to the client. One way is longer claims. The fact is, the longer the claim, the more the examiner is inclined to think that it's allowable. There's an old joke in the patent office that if a claim is as long as a pencil, it's allowable. That's a joke, but there's some truth to that joke in that, like I said, the longer the claim, the more the examiner thinks that maybe it might be allowable. Specificity in the claims is also important. If there's more structure, then the examiner is going to be more inclined to allow it. And by more structure, I mean many structural components, and it's described in the claim how they're connected and arranged and configured and work together, rather than something where there's just simply functional language attached to the claims structure. Another common question that I'm asked is whether there is a way for the examiner to pick up the application more quickly and get to that first office action. What I've found in my experience is that if there is a international search report or a foreign office action in the application, for example, cited in the IDS, that is helpful to the examiner and encourages him to pick up that application more quickly. So on the examiner's docket, there could be 10 applications, there could be 20 applications, and he's allowed to take any of those applications and work on them within his docket. So he does not necessarily have to work on the oldest application first. As long as it's on his docket, he is able to pick and choose which application he wants to work on next. If the examiner sees some sort of foreign report by a foreign patent examiner that shows that a search has been done and that there's been a determination on the patentability of the claims, that is going to be respected by the examiner, and that examiner can then use that as a guide for him to craft his first office action. Another thing that encourages examiners to pick up an application just a little bit earlier is if there's fewer claims. So on the examiner's docket, he can see on the application how many claims are in each application. And so if an examiner sees 25 claims on one application and 8 claims on another application, he's going to get the same amount of credit no matter how many applications there are. It's a strange quirk about the office is the examiner gets the same amount of credit no matter how many claims he has to decide. So the same amount of credit for each application. So if the examiner only has to examine, yes.
Then could you explain a little bit about credit means?
Sure. So the examiners have they have a quota. It's almost like a billable hour quota. So they have to get so many credits, or they're also called counts. The examiner has to get so many of these counts every 2 weeks, every quarter, and every year. And if the examiner doesn't get the number of counts that his quota requires, his job can be in jeopardy. There can be serious negative consequences. So each application is assigned for each first office action. The examiner gets 1 1/4 credits. For each final office action, he can get 3/4 of a credit. And so there's these different, an allowance can be half a credit or it can be a 3/4 of a credit depending on whether there was a final office action or not. And so as the examiner goes through and issues these first actions, final office actions, allowances, he accumulates these credits. And so that ensures that the examiner keeps his docket moving and these applications moving, and he's working and creating these office actions and reviewing applications. And so he has to accumulate enough credits to satisfy his supervisor and meet his quota. And these quotas are the examiner is reviewed to make sure that he's met these quotas, like I said, every 2 weeks, once a quarter, and once a year. So did that answer your question?
Yes.
Okay.
Thank you.
Sure. So during my time in examination, I've noticed some differences among the Japanese style claims and the examiner's preferred style claims. The Japanese style is from my experience, is to provide more of an advantage or a functional language within the claim and less structure. The examiner preferred style is to have lots of structure, like I mentioned before, with many different structural components and how they're connected and interacting and configured and arranged. So in other words, more specificity about the actual structure. So as far as providing protection and coverage for the client, one is not necessarily better than the other, but I'm simply pointing out that at the prosecution stage, the examiner does look at the structure, and that is more persuasive to the examiner. The next slide here lists what I call trigger words for the examiner. When he sees these words, these terms in the claim, he's going to think that he can interpret the claims very broadly. So these words that are very generic, portion, unit, device, assembly, member, part, mechanism, those kinds of words are sort of a license for the examiner to interpret claims very, very broadly. Here's an example. So in my experience, the Japanese style would be to say, claim something as a first plate portion, whereas the US style is to simply drop the word portion and say first plate. When the examiner sees first plate portion, he thinks it can be very nebulous and generic, and so if my hand is the plate and there's this protrusion jutting off of the plate, the examiner, if he sees the claim first plate portion, he thinks he could point to this protrusion as the first plate portion, whereas perhaps the Japanese applicant thinks that they're simply claiming the plate by saying first plate portion. So here's another example. In my experience, the Japanese style might be to say first movable part. Again, you see the generic word part there. And then the US style is more to be more specific. So And instead of saying simply movable, it's describing what kind of movement, pivoting. Instead of saying part, it's describing what kind of part and arm. So these are maybe one is not necessarily better than the other when in the real world, when we're trying to protect the client's interests and get the client the best coverage possible to protect him from competitors copying. However, just within the prosecution stage, and just noting that this is the sort of things I see and how the examiners can interpret claims more broadly than what is intended by the Japanese applicant. So the next type of rejection is the eligibility or abstract ideas under Section 101. So I examined medical devices that were dealing with using computers to diagnose diseases. In US patent law, diagnosis is considered a fundamental building block and it is considered not patentable. So I made a lot of 101 rejections. I had to defend a lot of 101 rejections. A lot of my 101 rejections were appealed, and I won most of the rejections. In other words, the judges affirmed my rejection, agreed with me that the 101 rejections were proper. So these are, so what I have listed here are criteria to determine whether a claim is eligible or not. The first one is practically done in the human mind. So in other words, if there's a calculation can be done in the human mind. But however, if it's an extremely complicated calculation, that cannot be practically done in the mind. The key word here is practically done in the mind. And in the next slide, I'll give an example of what I'm talking about with that. Another one is specific processing. The examiner is going to be more convinced that the claim is eligible if there's a specific type of processing involved. It's often that you'll see in a claim something that just says a controller or a computer, but if there is actual specific artificial intelligence going on, or there's a neural network going on, that kind of processing is going to be more persuasive to the examiner if the claim actually has that specific processing in it. Another criteria is the tailoring to specific industry. So if there's an for example, if the claim is dealing with a sensor on a transmission to determine the wheel speed of a vehicle, then it's going to be more persuasive to the examiner if that it's tied to the automotive industry. So instead of saying a sensor measuring the first unit to determine the velocity of the second member, that it's going to be more persuasive if it's actually tied to the industry. So it says the transmission and the vehicle and the wheel, and it is specifically tied to that automotive industry. And then finally, specific improvement in the technology. The improvement needs to be specifically stated in the claim, and it can't be part of the abstract idea. It has to be a real world application, and I'll get to I'm going to have an example of that in a little bit. So here's this is another application. This is actually also the Japanese company NTT. We rejected this claim initially because it simply said that the process was calculating a coefficient, and we said that could be practically done in the human mind. And you can see that after that first office action, they amended the claim to be more specific, and that's what I've highlighted here is the detail that they added to the claim to describe that calculation. And so it became clear to us after that after that amendment, that with that detailed calculation, that cannot be done practically in the human mind. And so we allowed this application. We passed it to issue and let it become allowed. So here is an example of where I would suggest a specific improvement can be claimed. So in other words, on the left is what an ineligible claim that I commonly saw, where you have a sensor, some sort of data gathering device, could be a database, could be simply manually inputting data into a computer. The computer does the analysis, and then it simply displays the results. Often you would see that Japanese applicants argue that there is an improvement to technology in the computer analysis. However, the case law is clear that the improvement to technology cannot be found in the abstract idea itself. There must be some sort of real-world application of that analysis, that computer analysis, to be considered an improvement to technology. So over here on the right is a claim that's patentable. So again, you have that sensor, that data gathering device, and then you have a computer that performs the abstract idea, some sort of a diagnosis, analysis, filtering, comparison, something like that. And then finally, there's a real-world application. So here, the diagnosis, the analysis is used to, in sort of like a feedback loop, adjust that sensor, whether it be calibration or sensitivity or something like that, to apply that improvement in technology. So going back to the claim on the left, simply displaying the results is not considered an improvement. There has to be some sort of real world application of that. So where I saw that commonly in the medical device area was, so there would be a diagnosis, the computer would perform some sort of diagnosis, and then that itself would not be eligible, but then the applicant would add at the very end something about wherein, based on the diagnosis, the patient was given 5 milligrams of saline, some sort of therapy or treatment. And so that is a real world application based on the analysis, the abstract idea of that diagnosis. So that's ways to get around the ineligible claims issues. Moving on to the next division, the appeals at the Patent Trial and Appeal Boards. At the Patent Trial and Appeal Board, PTAB, the judges will review rejections that the examiners have made. As I mentioned, I worked for a PTAB judge for 4 months, and during that time I was exposed to a lot of complex legal issues. One of the things that I noticed was with the Japanese applicants was that the arguments were not clearly set forth. The judges can't make up reasons to either affirm or reverse the examiner's rejections. The arguments have to be set right in front of the judge. They have to either just decide the case based on the arguments set in front of them by the examiner, or set the arguments out in front of them by the applicant. And so what I saw was that not a lot of times, but sometimes the arguments by the applicant weren't entirely clear, and so the judge had his hands tied because he has to go with what's in front of him. He can't make up his own reasons to reverse the examiner. And so he would end up having to affirm the examiner's rejections, even though there was some question about the validity of the rejection, because the arguments by the applicant in the appeal brief were not clearly set forth as explaining exactly what the problem was. Another task that the PTAB has is to review inter partes re-examinations. That's where there's 2 parties questioning the validity of the application, validity of the patent. Based on my experience working for a judge and my experience searching for prior art, I believe that I am skilled to provide this prepare and conduct these inter partes re-examinations for clients. The next division is the re-examination division. This is where the ex parte re-examinations are done. Ex parte re-examination is slightly different than the inter partes re-examination. The ex parte re-examinations deal with only one party, either the challenger or the patent owner. While I was a patent attorney in Denver, I had the pleasure of prosecuting re-examination applications during litigation where we were trying to invalidate the patent while there was an infringement litigation going on. And we were successful in getting the examiner to affirm the re-examination. So again, based on my experience in re-examination and my experience searching for prior art, I am qualified to help clients with prepare and prosecute re-examination divisions, to re-examination applications. Finally, there's the publications division. So application is finally allowed, and it goes to the publications division before the notice of allowance is mailed to the applicant. The the staff inside the publications division will review the text and specification for typographical errors. For example, if there's a table in the drawings and the table should actually be in the specification, the applicant will get a notice to change that. They review the assignment and declaration and application data sheets for inconsistency, and they ensure that the examiner has reviewed all of the IDSs in the application. So these are things that we can catch beforehand and correct beforehand so that we don't have to deal with these notices to file missing parts or correct the application once the application has finally been allowed. So I know that was a lot of information. Does anyone have any questions, or would you like me to go over a slide that I have talked about?
And the examination, AI is used in this examination.
They are experimenting with that now. So there is some AI used. The examiners have the option to use AI if they want. I tried it. Personally, I didn't find it very helpful. Some of the examiners liked it, but right now it's sort of in a beta experimental stage right now. So hopefully they can learn to use it more, because I think the attorneys are going to start using AI more. So in order to keep up, I think the examiners also need to start using AI more.
So many applications based on AI are filed.
Yes. Yeah, a lot of artificial intelligence applications. That's a very big growing area within the patent office, big growing technology, and they are having difficulty staffing examiners with that experience and knowledge to review those artificial intelligence applications.
Japanese company, SoftBank, filed so many applications by AI.
Oh.
So 1,000,
Really?
maybe.
Did they?
Higher.
Oh, did they use artificial intelligence to write the applications, or would the applications were about artificial intelligence?
The application is made. Main applications are made by AI and light specification by AI.
Oh, really? Interesting.
Okay,
Okay, well, thank you.
thank you very much.ありがとうございます。